Good morning, Judge Shapiro.
Good morning, Chrissy. You're not
How's it
seeing me
going?
yet, I guess, huh?
Nope, not yet.
Oh, here it is. I see. Okay. There's the
Perfect.
top of my head. Okay.
Okay, awesome. And you can hear me fine?
Yes. And also, that Mary Aretha is also going to be
Okay.
on, she's the clerk handling this. Okay. So do let her in.
Okay. All right, will do. I'll let you know when everyone gets here.
Very good. Thanks.
Hmm.
Oh, there we go. Okay,
Please.
perfect. Yeah.
Judge Shapiro, I will start letting the parties in. There is a Jacob Poland. I don't have him listed anywhere. As to
What's
what
his
party
last name?
Poland.
Yeah, I don't see him on my list. Yeah, ask him.
I did try to ask him, but it doesn't look like he's either not getting the chats or
Well, why don't you ask, see if anybody else knows?
okay.
Good
Good morning, Jacob. Could you let me know who you are here representing?
Yes, and I'm sorry, it says chat disabled, so I couldn't respond to your message. I'm here with
Okay.
Plaintiff's counsel. I have a per hoc fiche pending, and I don't plan to speak on the record.
Okay. Thank you.
Thank you.
Okay.
morning, everybody.
Morning, Your Honor.
Good morning,
Morning,
Are we,
Judge.
are we expecting anybody else?
There is a Wesley Dozier in the waiting room.
Yes,
that
Your
I-
Honor. Wesley is with my law firm. He just joined the case, my law firm and the case. And so I believe his admission is also pending.
And what is his name?
Wesley Dozier.
Dozier, thank you. Okay. Does anyone object to him? Oh, there he is. Okay. Morning, Mr. Dozier. All right. I guess we can go on the record then. Is the court report ready?
Yes, I'm ready. Thank you.
All right, very good. We are here today in the case of Jansen Rogers et al. Versus the Michigan Department of Environment, Great Lakes and Energy, as well as the Michigan Department of Health and Human Services and their respective directors. And we are here today on the defendant's summary disposition motion to dismiss on timeliness. And I'm just going to go through everyone who's present. It looks to me like for the plaintiffs, we have Ms. Jennings, Ms. Poland. Is Ms. Poland here? No. Oh, Mr.
Mr.
Poland. Mr. Poland, who I don't know if he's of record yet. Ms. Martin. Mr. Colson, is he here?
I am, Your Honor. Good morning.
Ms. Martin, I may have mentioned. Ms. Smith. Ms. Smith, which party are you with?
I'm here with the defendants.
All right. And Mr. Gamble,
Yes.
who is here for the defendant. Did I miss anyone?
Carl Edwards, good morning, Judge. I'm sharing Alice Jennings' computer this morning. How are you?
Morning, Mr. Edwards.
Yeah.
All right. Before we begin, just one housekeeping item. I received this stipulated order for dismissal of Kendria Bates, Kendasha Bates, and Rebecca Branscombe. And I don't, without prejudice, I don't believe I've signed it yet, but it is here on my desk. Is there anything I need to know about that? I'm content to sign it, but I understand. No. So any problems with that? All right, I'll sign that today. Okay. So we're here on defendant's motion. So Mr. Gamble or Ms. Smith, you can take it away. Just put your appearance on the record, please, when you begin.
Thank you, Your Honor. Nathan Gamble, Assistant Attorney General. I am here on behalf of the defendants, and it is our motion to dismiss the entire lawsuit. And one of the key issues here, I think, is the standard that the court will use to decide our motion. And both parties agree that the C7 standard is the one that governs the court's adjudication. And under that standard, the court looks not only to the pleadings, but to the evidence that is submitted by the parties. And when the defendant's evidence contradicts allegations in a plaintiff's pleadings, under the C7 standard, the plaintiff cannot just fall back on those allegations. Once they're contradicted, the plaintiff needs to generate their own evidence to put a material fact genuinely at issue. And that has not happened here. The plaintiffs have not submitted evidence. Instead, they really respond to defendant's motion as if it is a C8 motion, which it is not, and fall back repeatedly and in great detail on their contradicted allegations. But the law is clear in Michigan that that is not a way that they can put a material fact genuinely at issue. So when the court looks at the uncontradicted pleadings, along with the evidence that the parties have submitted, there is no material fact genuinely at issue here, which means under the C7 standard, it's a matter of law for the court to decide the timeliness of the plaintiff's complaints. Now, as to when the plaintiff's claims accrued, defendants had tried to get in front of this issue with their motions related to the adequacy of the plaintiff's pleadings. And from the defendant's perspective, we looked at their complaint they filed. They said, we were exposed to and injured by water that gave rise to our personal and property damage claims back starting in 2018. We want to represent a class of people starting in 2018, dating back to that time. They didn't identify a specific month, though. So in our answer, we said, well, it looks to us, basically, your claims, the events giving rise to your claim happened in 2018, but we allege it was October 2018, since that's, as far as we could tell, when all this started. And in their reply, it surprised us. The plaintiffs denied that. They said, no, that's not when our claims accrued. So, but they didn't explain why. And that was what triggered the motion practice. And in the course of that motion practice, the plaintiffs took a position. They said, yeah, we were injured back to 2018, but our point in our answer, or our point in our reply, was that our injuries are ongoing. And what we plan to do is rely on the fraudulent concealment provision in the RJA to toll our untimely claims. So from our perspective, that's fine. That's why when we filed our motion, we focused almost entirely on what we thought the issue here was, which is the fraudulent concealment provision. And sure enough, in response to our motion, the plaintiffs are from our perspective, trying to change their position. We don't think that that's permissible under the doctrine of judicial estoppel. Judicial estoppel is designed to prevent this type of maneuvering.
So how, I'm sorry, how have they changed their position? Run it by me again. Is it because of the fraudulent concealment or something post that?
They took the position in the briefing that they were injured starting in 2018, but their injuries were ongoing. And we wanted a more explanation. Why are we talking about whether or not your claims accrued in 2018 or not? Because your complaint sure seems to say that it does. They said, well, what we meant in our reply is that our injuries are ongoing. And if our claims are too late under the 6-month rule, we'll rely on the fraudulent concealment provision. And this court granted that, or excuse me, accepted the plaintiff's position, denied our motion. They took a winning position, which was fine. I mean, that resolved the issue. And so now the issue for the for the defendants is, all right, does fraudulent concealment actually toll their claims the way they say it does? And we don't think that it does. We think the evidence is pretty clear on that. Now, here's the thing. Even if the court decides that the judicial estoppel does not apply here, just doing an ordinary accrual analysis based on the allegations in the plaintiff's complaint, the statements they made in their briefing so far, still demonstrates that their claims accrued much more than 6 months before they filed suit. They recognize that their claim can accrue without knowledge. That is the law in Michigan. Your claim can accrue without knowledge. They concede that point, as we point out in our reply brief. The complaint alleges they were injured back in 2018 by the defendants. The things they accused the defendants of doing that caused them this injury are things that happened in late 2018 or at the latest, February 2020, when Eagle changed the treatment protocol for the city of Benton Harbor's water system. Either way, these are things that happened more than 6 months before they filed suit. So the issue here is whether the defendants actively tried to keep the plaintiff's claims from them. And the evidence that the plaintiffs have, or excuse me, the evidence that the defendants have submitted in great detail demonstrates the exact opposite. And really, plaintiffs don't have—
Mr. Gamble, let me ask you a question about the fraudulent concealment. Since discovery is open until May of 2024, why isn't your motion premature? Since certainly fraudulent concealment would seem to be something that would be, discovery would be relevant to.
It's not premature because existing precedent allows us to bring this under C7. And
I don't doubt that you have authority to bring the motion, but I could also have authority to say, if this is going to be a C10 standard pursuant to C7, then I should consider whether or not the motion is premature, given the factual development.
Well, the answer to your question, Your Honor, goes back to the first point that I made at the beginning of this hearing, which is that the C10 standard isn't what governs here. This is a C7 motion. And under the case law for— pardon me.
I'm sorry, what is the standard? You're probably about to tell me. When C7 is based upon matters outside the pleadings, as it is here, since you're submitting material, what is the standard that's applied?
The evidentiary standard, the way the court determines if there's a genuine issue of material fact, is to look at the evidence the defendant submitted and then consider the uncontradicted plaintiff's allegations in their complaint. Now, the case law that we cite in our briefing shows that a plaintiff cannot cite their contradicted allegations to create a genuine issue under the C7.
I understand, but could you answer specifically my question as to why, given that we have another 6 months of discovery, why this motion is not premature? I understand what you're saying, but I mean, if we're essentially looking at facts, I mean, is it your position that that C10 is the C10 looking at the factual development and how we look at it is irrelevant in a C7 motion that discusses evidence?
I'm trying to understand your question, Your Honor. The C7 standard and the C10 standard are different. And the reason that we're raising this now is
Well,
because
tell me what the C7 standard is when the moving party cites evidence outside the pleadings.
it's to determine if there's a genuine issue of material fact as to the timeliness of the plaintiff's complaint.
And if discovery would reveal information regarding fraudulent concealment and discovery is not yet complete, why isn't, not that the motion should be denied, but why isn't it premature? That's what I've been trying to understand.
I apologize, Your Honor. I'm not trying to be difficult, but that's—
Why wouldn't the grant of the motion be premature, I suppose I should say.
The point I'm trying to make, Your Honor, is that someone has to, in order to survive a C7 motion, the plaintiff has to demonstrate that a material fact is genuinely at issue. And simply saying discovery is not done yet isn't a way they can do that. They have to resurrect somehow their contradicted allegations. And the case law that we cite, I think, is fairly clear on this, that you can't just fall back on your pleadings. When the defendants are entitled to essentially bring this to the court's attention promptly, when there is an issue under C7, there are a series of defenses available under C7 in order to have it adjudicated promptly, rather than wait until right before trial or after discovery is completed. That's what we have done here. Is we think the facts and the evidence are so clear. There's really no genuine issue of material fact that fraudulent concealment does not apply here. And the plaintiffs haven't responded with any of their own evidence. So what they've done is failed to create a genuine issue of any kind about any material fact. They just fall back on their contradicted allegations. The court looks then at the record that exists right now as we speak to determine if there's a genuine issue, and there isn't one. The defendants here plainly followed what is the standard practice anytime there's an action level exceedance for lead in a water system, which is require that system to immediately notify its users and educate its users about how to protect themselves and mitigate the impacts of lead. That happened here. And the plaintiffs, really their argument is that there's no meaningful difference between this situation and the situation in the city of Flint. And I think that the defendant's briefing, we really make pretty clear that there's a big difference. In Flint, there was no action level for lead. It was the state defendants in Flint who were instrumental in changing the water system, the water source in Flint. And then when outside groups said there was lead in the water, it was alleged that the government said, no, there isn't. You have nothing to worry about. That is fundamentally different from this situation, where the state had nothing to do with getting lead in the city of Benton Harbor's water. It just showed up in testing. So there was an action level exceedance for lead, which triggered just a cascade of public notification and public education requirements that was extensively reported on the media. This was not some hidden thing that came to light once it received national media attention. This was a major issue in the city of Benton Harbor for years. It was extensively reported on by local media. The city held a public town hall, was in constant communication with residents about this issue. It was not some secret. And it's hard to overstate how different the circumstances are here.
Oh, I read your brief. I mean, I understand the efforts that were made, unlike Flint.
And so really the key here from the defendant's perspective is there some tolling doctrine that makes it so the plaintiff's claims are timely? And there isn't. The fraudulent concealment provision, which is the one they said they were going to rely on, doesn't apply here. What they allege, they should have known of a potential claim much more than 6 months before they filed suit. And it's an objective standard. It's not a subjective standard. And even if it were subjective, none of the plaintiffs submitted an affidavit of any kind. We have only their attorney's statements to know what the plaintiffs might have been thinking at a given time. And that's not evidence. And the So they should have known, and there's no genuine issue of material fact that the defendants didn't actively try and conceal anything from these plaintiffs. There's no evidence the plaintiffs submitted to make that argument. They rely entirely on their contradicted allegations, which is not allowed under the C7 standard. And the same applies for the harsh and unreasonable consequences tolling doctrine. We explained in our brief why it doesn't apply. Same analysis. The evidence doesn't show that the defendants were hiding anything from the plaintiffs. And so really the legal analysis here, even though it's kind of a complex factual record, the legal analysis here from the defendant's perspective is fairly straightforward. The plaintiff's claims accrued more than 6 months before they filed suit, and there's no tolling doctrine that saves their claims. Their claims are untimely. And for that reason, the defendants have moved to dismiss the complaint in its entirety.
Thank you. And who is going to respond for the plaintiffs?
Good morning, Your Honor. I am Annika Martin.
All right, Ms. Martin, you can proceed.
Thank you, Your Honor. So first, I just want to zoom out a little bit before I drill back down to address Mr. Gamble's arguments. This is a case where we're dealing with a procedural limitation to access to the courts for residents of a town that are dealing with serious damages related to consumption of lead in their water, which really causes permanent harm. So this is a really serious situation for the residents of Benton Harbor. And I just want to start with a quote from Judge Bernstein in the Mays appellate opinion, where he said, this court, and he meant the appellate court, should never elevate adherence to convoluted legalism and procedure over the well-being of Michigan's people. And I think, it's important to remember that as we go through here. Your Honor hit it just right about factual development. That is critical here, whether we're talking about the accrual date or fraudulent concealment or harsh and unusual consequences. The focus here is—
Let me stop you, and maybe you're going to get to this. Why do you need factual development on the accrual date, since you're the one who's got the injured people?
Sure, Your Honor. So the accrual date concerns all of the elements of a cause of action being present, existing. And we have a focus here on the defendant's conduct. So Mr. Gamble talks a lot about the first action level of cedents in 2018. But that is not our focus. I mean, certainly that is the first moment when there was a realization that there was lead in the water. But our focus in this case is on the defendant's conduct in communicating about the lead in the water to the residents of Benton Harbor for 3 years. And this gets a little bit to his argument that Mays does not apply here. I mean, Mays is it here. It's completely on point. And really, Mr. Gamble has utterly failed to distinguish it. Mays, in their reply, Mr. Gamble says that in Mays, the defendants failed to disclose the toxic nature of Flint water, and that here the defendants notified the residents of Benton Harbor of the potential presence of lead in the water and how to protect themselves. The key here is the toxic nature of the water. In Flint, they didn't disclose the contamination at all. And here, they disclosed potential lead, but said it's fine. We have these filters, flush, and it's fine. And it wasn't fine. In both situations, the toxic nature of the water is don't drink it. You can't drink it. And for 17 months in Flint and for 3 years in Benton Harbor, residents were not told not to drink the water. The cover-up here, certainly there was disclosure that there was lead in the water, but the cover-up here is that the filters didn't work, the flushing didn't work, and the water was not safe to drink despite those precautions. It seems like Mr. Gamble's logic here is that the residents of Benton Harbor knew they were drinking toxic water for 3 years if they chose to do so anyway, and then for some unknown reason, in early 2022, they changed their minds and decided to sue. It just doesn't make any sense. What happened was that they learned that their government had been lying to them, covering up, and giving them a false sense of security about the toxic nature of the water for 3 years. And in that way, it's just like Mays, which is why I'm going to talk about Mays a lot, and we talked about it a lot in our briefing. Mr. Gamble talks about the C7 standard needing to generate our own evidence, and I think Your Honor was sort of approaching this, which is that in this situation, the evidence about defendant's conduct is in the defendant's possession. And so the factual development needs to happen in order to have the evidence that we need for the aspects of the accrual date that have to do with the defendant's conduct. For example, which of their many elements of misconduct were the ones that rose to the shocking the conscience level. For the fraudulent concealment, we need to know about the defendant's conduct. The kinds of things that we need to know are all the data that they had about the effectiveness of the filters, the limitations of the filters, how the filters were distributed, installation and maintenance of the filters. All of that stuff is in their possession. Information about the distribution of the notices that were given, because there is evidence that it wasn't the notices that were given were not distributed broadly enough. Information about the corrosion in the pipes, what the defendants knew and were doing about that, the control measures for the corrosion, the decision-making behind that, the ineffectiveness of the corrosion control, the related sampling and data behind the corrosion control, information about replacing the lead pipes and the decision-making regarding doing that and the timing, the information about issuing the no drink order, why all of a sudden were they doing it then and why did they not do it previously with what they knew. Certainly any water testing and sampling results 2018 onward that have not been made public, we wouldn't need to know. So all of these are things that are factual development that will then inform
Martin, let me interrupt you for a minute.
Sure.
Haven't depositions of the players on the defense already been taken, at least some of them?
No, Your Honor.
Okay. Well, what is the discovery status of the case? Where are we, in paper discovery or experts? Or, well, not experts yet, I imagine.
So, Your Honor, we have served some discovery requests and had a meet and confer about them, and are working through the disputes about their responses to those discovery requests. But thus far, I don't believe we've had much produced, if anything. Mr. Colson can.
Your Honor, just briefly, there was a very limited scope of just written discovery that the court authorized earlier in the case. We've worked through that, but we've now just begun to broach what I would consider to be the general mainstream discovery of the case. And we've not had a single document produced from that yet. We're dealing with, we're going back and forth conferring about the scope of various productions and reasons that the defendants say that they don't want to produce certain things. But this is precisely the sort of situation where, regardless of which device it is, C7, C8, C10, we cite in page 8 of our brief, the Oliver case. Generally, a motion for summary disposition is premature if granted before discovery on a disputed issue is complete. Here, we have only begun to scratch the surface of discovery on these disputed issues.
Okay. Then we can return to the substance with Ms. Martin.
Thank you, Your Honor. So that's exactly right. So we need this factual development, and it's needed for any of the 3 ways that we have argued that this case should go forward, whether you're looking at what the actual accrual date is in terms of for the notice period running, or if you're looking at either of the 2 exceptions, which would relieve the plaintiffs entirely of having to comply with the notice provision. And that's fraudulent concealment and the harsh and unusual circumstances. Both of those require this kind of factual development that Your Honor was alluding to. And because the focus of our claims is on the defendant's conduct, it's information that we cannot have until we have had the opportunity to get discovery from them. So really, any way you slice it, factual development is going to be needed so that the plaintiffs have an opportunity to really get over the threshold of the courthouse door, and they should have that opportunity to do so, to prove their claims. As Your Honor said, it's 6 months left, and the motion can be considered at another time.
All right, as we sit here today, I have I've looked at the exhibits. Are you relying on any of the bulletins and so forth in which, I mean, I don't really remember what's exactly in there, to tell you the truth. It's a fat notebook, but let's say the public evidence regarding the statements that were made, do you rest on those as, putting aside what you might discover in the future, do you rest on those at this time, if we were to look at the evidence, that establishes either fraudulent concealment or the other exception?
Just so I understand your question, do I think that we have enough evidence now with what has been attached to our complaint to establish that there has been fraudulent concealment or harsh and unusual?
Well, to establish a question of fact as to those.
Oh, yes, Your Honor, absolutely. We have, frankly, we have in this case a lot more evidence than we have in many cases that we file about a defendant's conduct, and you have an asymmetrical information situation. I do class actions solely, and in all of my cases, the defendant has all the information about a defect, about the fraud they perpetrated, whatever it is, and the plaintiffs typically have none of the information about the defendant's misconduct because it's all internal information. In this case, because of the FOIA requests and the information that was publicly released, we actually have more information than you have in most cases at the outset. So certainly we have attached quite a lot to our complaint, what we could attach. But again, as I just went through the sort of laundry list of other information that we don't have, we need that in order to determine the accrual date, in order to prove the fraudulent concealment allegations, or to prove the harsh and unusual consequences. But I certainly think from what we do have, that Your Honor can see that we are heading in that direction, and we will be able to prove it with discovery.
Yeah. Anyone else speaking other than Mr. Gamble in response? Okay, Mr. Gamble.
Thank you, Your Honor. To provide the court with additional information about the status of discovery, the defendants have also issued discovery requests, both requests for production of documents and interrogatories to the plaintiffs. The plaintiffs just made responses, I think, last week to those. And so the defendants are still reviewing them to determine what disputes there may be. The plaintiffs have not produced any documents to defendants, and defendants have not produced any documents to the plaintiffs, but that's because the stipulated order that all the parties agreed to is that no production would take place until a ESI protocol and a confidentiality order were established. The parties are still working through an ESI protocol. The defendants are just still waiting for the plaintiffs to produce a draft confidentiality order.
Right? Did I sign that? Because I'm looking at the order and I don't see that, but I may have signed it and not remember it.
Yes, you did, Your Honor, and it was a stipulated order, Your Honor. The parties all know what was in it,
and Your Honor, we did not intend to suggest that the defendant has been, non-compliant with discovery obligations or anything other than that, other than just to say we're very early in the process. So
okay, got it. Thank you, Mr. Gamble. Go ahead.
And in terms of Ms. Martin's response, I would understand her response entirely if this were a C8 motion, but it is not.
Mr. Gamble, I am not always on the ball, but I don't think I'm quite that thick. I've read a lot of C7 cases, and if it's not on the pleadings, the issue is whether there's a question of material fact, just like under C10. So you keep saying C10's got nothing to do with it. I'm lost, other than that you would like it to have nothing to do with it.
No, Your Honor. The defendants are entitled to raise these factual issues now, and Mr. Colson's right. If there's a genuine issue of material fact, it is not generally practiced for courts to grant a dispositive motion. But the point that I keep trying to make is that you can't.
It's the law that you can't grant it, right? If there's a genuine issue of material fact.
Yes. Okay. But the point I'm trying to make, Your Honor, is that you can't put a material fact genuinely at issue with your pleadings. That's not how it works under C7. You can't contradict our evidence by just falling
I
back on
understand.
the
So,
issue.
so if someone files, let's forget about immunity for just a moment. If someone files a claim, and you know, there are issues there are issues that involve materials or knowledge that would be in the hands of the defendant, and the defendant files an SD motion on C10 right out of the box, it would be improper for a court to say that was premature if the plaintiff has not yet presented the evidence that would likely be in the hands of the defendant.
If the basis of the motion was C10 and what the defendants were arguing was that there was no genuine issue of material fact as to the merits of the plaintiff's claims, then yes, that would be premature. But C7 lists a variety of defenses, including statute of limitations, and authorizes defendants to accelerate the factual issue, to put it right in front of the court right away, because those are the types of defenses that, if a defendant can successfully rely on, just ends the lawsuit completely. It's not just statute of limitations. It's also, you know, if the plaintiff for some reason had agreed not to sue or something like that. If the plaintiff had agreed not to sue and sued anyway, the defendant can bring a C7 motion and say, here's their agreement not to sue. There's no genuine issue here that they agreed not to sue. And the plaintiff couldn't just fall back on their complaint. They would have to produce evidence saying, no, that's not what the agreement means. We need further factual development here. That's not what happened here. The defendants have produced evidence.
Oh, I understand I do understand. I just had that question, but you can continue to respond, but you don't have to explain that to me any further. I get where you're at on it.
Okay, thank you. I apologize. I don't mean to belabor that point.
Not at all. I'm the one who asked the question. So,
you know, really at this point, Your Honor, the issues that the plaintiffs are raising in this hearing are really quite different than the issues that they raised in their briefing. You know, now they're saying they need additional discovery. They don't really identify what facts. The facts that Ms. Martin did identify are all things that the evidence contradicts, and they don't have any affidavits from their clients saying.
But for example, wouldn't it be relevant if someone from the defense said in deposition, and I'm making this up, you know, when we issued the thing that said use a filter, we knew that this was poison and that people needed to stop drinking it. Would that be relevant?
I suppose that would be relevant. That evidence does not exist.
Well, right. Okay, fair enough.
Yeah, that doesn't exist. That isn't, you know,
well, you don't know if it exists, so you're not going to tell me if it does exist. The plaintiffs don't have possession of any such evidence, right? We don't know if it exists or not.
Well, they allege that there's something along those lines, but they have no evidence. They don't have any affidavits. They don't point out why the tremendous amount of evidence the defendants have produced and made available to the court is wrong. The fact of the matter is that there's no real distinction between Benton Harbor and the other 60 water systems in Michigan that have also had action level exceedances for lead, or the hundreds of other water systems in this region of the United States that have also had action level exceedances for lead. Just because there's an ALE for lead doesn't mean that every single house on a system has excessive amounts of lead in the water. That's why the regulations are written the way they are. And really the core of the plaintiff's argument here is that the defendants had a legal obligation under the federal and state Safe Drinking Water Acts to immediately tell everybody in the city of Benton Harbor to stop drinking water immediately. That is not correct. They cite no provision of the law that puts that burden on the defendants. They even admit in their reply that the Department of Health and Human Services has no obligation of any kind under the state or federal Safe Drinking Water Act. And the evidence that we produced shows that the EPA looked at this issue and did not find what the plaintiffs allege that they found. What the plaintiffs allege is that the EPA issued an order to Eagle and DHHS finding that these two state agencies had violated the law. That is not correct. The evidence shows that Eagle invited EPA to the city of Benton Harbor back in August of 2021 to help bring more resources to this enforcement situation with the city of Benton Harbor, and that the order the EPA issued had nothing to do with the content of any of the public notification or educational materials, and it was not directed at either Eagle or DHHS. That's just one key example where the evidence so clearly contradicts the plaintiff's allegations, but in their briefing and response, all the plaintiffs do is fall back on those allegations to insist that it's too soon for the court to rule on this. But the defendants are entitled to raise this issue now. And under C7, if there's no dispute, genuine dispute about the facts relevant to the application of the fraudulent concealment provision, then it means the plaintiff's claims are untimely. And the defendant shouldn't have to continue to litigate a case when one of the defenses under C7 is immediately available and can be ruled on now, which it can. And that's really the heart of the defendant's position on this matter, Your Honor. If the court doesn't have any additional questions, I don't have any more.
I don't.
Okay.
All right. Very good. I've heard your arguments. I've read the briefs. I will start on drafting something in the next few days. I can't say exactly when it's going to come out. But I assume whatever I do, it's either going up on because its case has been dismissed, or it's going up because it's an issue that relates to immunity. And I don't know when the case will be back, but we'll see what happens either way. Is there anything else?
Might we respond really briefly to what I view as a very simple misstatement of the law?
You may, but keep it brief, please. And go ahead.
Certainly. The only issue, Your Honor, is cited in our brief in the Oliver case that I referenced before, is that it's not that a motion for summary disposition is premature if it's granted before discovery on a material issue or a genuine issue of material fact is complete. It's if it's granted before discovery on a disputed issue is complete. These are two very different things. This is a much lower standard. And this is the very purpose of this, is that you don't get to sit here as a defendant and say, here's all of our evidence that shields us from you getting access to our evidence. And so that's why it's a disputed issue and not the term of art of a genuine issue, a material dispute. Or a genuine issue of material fact.
Okay.
Thank
All
you.
right. Very well. So this hearing is concluded, and I'll get you an opinion as promptly as I can. Thank you.
Thank you, Your Honor.